Welcome to Vanderbilt Law School. For all of those of you who've traveled here, my name is Daniel Gervais. I'm the director of the IP program at Vanderbilt. Let me just give you a little bit of information about not the law school, but certainly the journal that's organizing this symposium, and a few practical bits of information about our program today. We're very proud of JetLaw, the journal that is organizing this annual symposium. I started at this law school 10 years ago, this year. Yeah, and JetLaw was ranked 420 in the law reviews. Now it's 119. That's not bad. In 2016, JetLaw was ranked number 1 for impact factor in arts, entertainment, and sports category, number 1 in the nation. We are now 5th in IP. That means we're right behind the Harvard, Berkeley, Stanford, and Yale journals of law and tech. This did not happen by accident. The JetLaw team, the students who are here and those who will be with us later, put their heart and soul into it, and I know because I'm the faculty advisor to this journal and I see how hard they work. So I'm very thankful to the student team and to all of the scholars who are here today to contribute to the success of this journal. So I will end here and turn it over to Professor Rochelle Dreyfus from NYU and Susie Frankel from Victoria University in Wellington to get us started.
Professor Frankel and I started thinking about this issue several years ago. At that time, the intellectual property IP professoriate and bar were just getting their heads around the fact that under the TRIPS agreement, a state's domestic IP measures could be challenged by other states. Prior IP agreements, the Paris and Berne Conventions, weren't, as a practical matter, enforceable, so this was quite new. And worrisomely, because TRIPS requires states to recognize rights, but makes flexibilities optional, states were using the flexibilities to regulate in ways that were engendering considerable suspicion. As we were busy trying to fathom that limitation on sovereign power, along came Investor-State Dispute Settlement, ISDS. Now, bilateral investment treaties, BITs, and certain free trade agreements had long included protection against expropriation and against denial of fair and equitable treatment. Here's the NAFTA provision, so you can see what that looks like. And IP was virtually always on the list of investments that states were obliged to protect. Yet there had not been a straight-up challenge to a state regulation of IP until 2011 and 2012, when Philip Morris brought complaints against Australia and Uruguay over rules on the plain packaging of cigarettes, which constituted a constraint on the use of their tobacco trademarks. And Eli Lilly brought a complaint against Canada over its promised utility doctrine, which limited the availability of patents. Susie and I saw in the progression of regimes an alteration in how IP was conceptualized. We wrote an article about what we saw as an evolution from incentive, the goal of domestic IP legislation, to commodity, how IP was treated when part of the World Trade Organization, the WTO, to an asset protected as an investment. In it, we argued that reconceptualization significantly restricted opportunities for pluralism because it reduced the flexibility that countries had to adapt the law to their own situations and values. If left unchecked, we thought the change posed a threat not only to health, culture, and education, all of the things that IP is related to, but would also frustrate innovation, the very thing that IP was supposed to support. Now, that article was published before the ISDS awards were handed down. In fact, the states prevailed on all of these actions. The Australian case was dismissed on jurisdictional grounds. I'll get back to that. And Uruguay and Canada both prevailed on the merits in their cases. As a result, the champions of ISDS, and there were quite a few, our article got a lot of pushback, suggested we had actually nothing to worry about, that investment law left states plenty of room to regulate, and moreover, that ISDS was effective. Effective because although Canada prevailed in the dispute, the Supreme Court of Canada soon overturned that promised utility doctrine just in the way that Lilly had advocated. We, however, disagree that the recent history shows there's no problem. We think there's a lot in these cases to worry about, and that they are essentially invitations for more ISDS challenges, and in fact that they provide a roadmap for using ISDS to chill legitimate regulation for important public purposes. So I'm going to talk about why we say that, and then Susie will discuss a couple of other issues. First, she'll take a quick look at new investment agreements, which pay more attention to ISDS, but we think not in a way that does enough to curb the impact of ISDS on legitimate regulatory activity. She's then going to go on to talk about reconceptualizing ISDS, at least in the IP space, where the intangibility of the assets raises a question about what constitutes an investment in the state. If there's time, and perhaps on the next panel, we'll also mention how the close connection between IP and fundamental values demands we think more about what's actionable in these disputes. So why is ISDS a concern? Let's start with the dispute I know best, which is Lilly against Canada. So Lilly is a US company, so the complaint was based on NAFTA's investment chapter. Lilly's claim, as I said, was related to the Canadian utility doctrine. NAFTA and the TRIPS agreement require countries to protect inventions that are, among other things, useful, and Canada and the US both actually impose a utility requirement. In the US, it's a fairly weak screen. The applicant must articulate a use, and as long as he or she provides enough evidence to convince a person having ordinary skill in the art, which we lovingly call facita, person with ordinary skill in the art, that the invention has that use, the requirement is met. But Canada had that promised utility doctrine. The patent office, or in litigation the court, was supposed to read the entire patent and deduce the uses it promised. The patentee either had to show, as of the filing date of the application, that the invention had those uses, or that they could be soundly predicted from the evidence that was presented. Now, Lilly had two drugs, Strattera and Zyprexa. The active ingredient in both was known well before the patent was filed. But Lilly claimed it had found surprisingly new uses for each of these, utilities that weren't previously known. So per Canadian law, it had to have submitted, as of the filing date, sufficient proof that the compound really had those uses or that they could be soundly predicted. The patents were granted, and both drugs later proved to be popular. But when the patents were challenged in court, they were invalidated on the ground that as of the filing date, Lilly hadn't demonstrated those surprising new uses. So Lilly brought an ISDS complaint alleging that the application of the doctrine came out of the blue, conjured up after NAFTA went into effect. It wasn't consistent with the TRIPS agreement. It undermined Lilly's expectations of making a heap of money off those drugs, and thus it amounted to an indirect expropriation of its property and a denial of fair and equitable treatment. Now, I don't have time to go through the entire case. I'll just show you a few things that make us worried about ISDS. The first thing to see is how ISDS creates new categories of challenge over and above what's available in the WTO. To see how, ask this question. If Lilly was right that this was inconsistent with TRIPS, why didn't the US bring a case in the WTO? And the answer to that is that US law is actually awfully similar. Here in the United States, too, Lilly had to submit proof of these surprisingly new uses, albeit as a matter of non-obviousness rather than utility. The proof had to be enough to convince facita, sort of like sound prediction. It had to be submitted by the filing date, and the law on this issue had changed after NAFTA. So that goes to show how much framing matters. That thinking of IP as an investment opens up avenues for challenge that wouldn't have existed under the WTO system. It also shows how little the interests of investors align with those of states. States have to worry that what goes around comes around. If the US won in the WTO, it could have itself become a target of challenge. But no one can go after investors in either ISDS or WTO actions, so they can be much less bashful about what they complain about. The second problem goes to a somewhat unique feature of the Canadian case. In most ISDS disputes, the challenge is to legislation. This was to a judicial decision. What happened was Lilly didn't like the trial court decision, so it appealed all the way up to the Supreme Court of Canada. When it lost there, it saw ISDS as the next step. Now, if there's going to be ISDS, common law and civil law countries have to be treated alike. There might, after all, be courts that do make up weird law for nefarious purposes. But it can't be that ISDS creates another round of appeal. And the tribunal was alert to that problem. But it could have made it clear that to bring an action, the investor needs to show a lot, a denial of justice, or even a gross denial of justice. But the tribunal didn't quite do that. Instead, it said that manifest arbitrariness or blatant unfairness could be enough, even if there was no actual denial of justice. Now, since Canada has a world-class judiciary, this tribunal wasn't obliged to actually apply this standard in any great detail, but it left it hanging out there for future investors to argue that decisions that they don't like, quote, crystallize a taking. And that's quite an invitation. Third, consider the argument that Canada's requirements violated investment obligations because they came out of the blue. Here, the tribunal could have said, stuff happens, and states have to respond. Since investors have to expect such changes, change in and of itself can't amount to an expropriation or an FET problem. But that's not what it did. Instead, it examined Canadian law in incredible detail to see how the promise, the sound prediction, and the filing date requirements were introduced. Only when it decided that they were introduced slowly, that the changes were incremental and evolutionary rather than dramatic, did it decide in favor of Canada. And that poses a significant impediment to regulation. Big changes can be necessary, and besides, there's almost always room to argue that the change wasn't slow enough. So for those of you who do patent law, think about US patent law. When trolls started using threats of permanent injunctions of leverage, Bing, the Supreme Court decided eBay against Merck Exchange and altered the availability of injunctive relief. Or when inventiveness got out of hand, Bing, the Supreme Court decided KSR against Teleflex and introduced a new standard. Ironically, Lilly itself, Lilly and Co., persuaded the Federal Circuit to change the written description requirement in a case called Ariad against Lilly. That was in 2010, and we're still arguing about whether that rule came out of the blue, and the better answer is yes, it did. So finally, this idea that the change made in AstraZeneca showed the effectiveness of ISDS. In fact, AstraZeneca was very different from the Lilly cases. It had proof as of the filing date that its drug had the claimed use. The trouble was the trial court read in new promises and then expected to see proof of them, proof of promises that AstraZeneca hadn't thought it made. In contrast, remember, Lilly failed to prove uses it had, in fact, promises. That's why the Supreme Court reversed. Requiring proof then on accounts of uses identified now is basically impossible. In fact, what this case shows is the wisdom of international law. It paints IP requirements with a broad brush and then leaves it to the states to use their familiarity with their own institutions to implement those standards appropriately. Here's how the TRIPS agreement puts that. ISDS is in tension with that approach. We can see that tension in the Uruguay tobacco case as well, albeit in a somewhat different way. Again, I'll just give you a few highlights. So this case is based on a bit between Switzerland and Uruguay. On the merits, it's a better decision than Lilly. Lilly had no facts to back up any of its assertions, as the Lilly panel actually found, so the tribunal could just throw out standards without bothering to show how they applied. Here, there were facts galore. Uruguay required that 80% of cigarette packaging be given over to health warnings, including these disgusting kinds of pictures. It also required the companies to choose a single presentation. They could sell only one variant, regular or menthol or light, not all three. The entire point was to reduce cigarette smoking by diminishing the cognitive power of the trademarks. Consumers were supposed to think that and not that. All right. So this tribunal had a clear loss of value to consider. The question was whether it amounted to an expropriation or a denial of FET. And the tribunal did a reasonable job determining the measures were fine. But consider again a few points. First, the tribunal had an open question of international trademark law to decide, whether Philip Morris had a right under the TRIPS agreement to use the mark or only a right to exclude others. Finding a right to use would have posed a dramatic impediment to regulation. Happily, in my view, it didn't do that. It decided there's only a right to exclude. However, it went on to say that even so, the packaging restrictions could diminish value enough to amount to an expropriation. Now, that might well be right, but it leaves a great deal of leeway for investors to challenge how far states can actually go. Furthermore, the tribunal took a bit of a shortcut. It didn't look at each of the claimants' marks separately. It looked at the value of the assets as a whole, and that made it relatively easy to conclude that there was not enough of a reduction in value. People in Uruguay were still smoking and buying the cigarettes. So it wasn't an expropriation. But it does leave room for other investors to frame their cases asset by asset. Second, Uruguay had claimed that under international law, the exercise of police powers trumps investment obligations, and happily the tribunal accepted that rationale. Still, to win, Uruguay needed to show that there was indeed a relationship between trademark restrictions and protecting health. That same issue came up with regard to the FET claim. To show the measures were fair, Uruguay had to demonstrate that they were not arbitrary and were instead actually related to health. For the most part, Uruguay could do that fairly easily. It adopted most of the measures under the World Health Organization Framework Convention on Tobacco Control, the FCTC, and the Pan-American Health Organization, PAHO, had made similar recommendations. But what about states that want to try something new? But states that want to try something new yet don't have resources to develop an evidentiary case. In fact, the single presentation requirement was novel. It wasn't one of the FCTC's recommendations, although the WHO and PAHO backed it. But that led to a partial dissent by Gary Bourne. Uruguay had claimed that the designations like light and menthol misled consumers into thinking that cigarettes were safe. He didn't see how the presentation requirement was logically related to misleading consumers. So without empirical evidence, he was not willing to defer to Uruguay. A third troublesome aspect. There was an allegation of denial of justice because one of the regulations had been challenged on constitutional grounds in the Supreme Court and on legality grounds on an administrative court, and the two decisions were irreconcilable. The majority dismissed this partly as a quirk, partly because it saw the courts as having different functions. But Bourne would have none of it. He wanted, if not a total reorganization of Uruguay's court system, then at least an avenue for the claimant to appeal the second decision back to the first court. So to sum up, even though the states won these cases, investors have ample bases on which to challenge regulations that improve social welfare whenever they have an impact on IP. And if Gary Bourne's dissent is influential on other tribunals, and he's a very influential kind of a guy, then states may have to develop extensive evidentiary records to support their regulatory actions and organize their judicial system in a particular way. And in light of the Canada case, that way better include a slow and highly deliberative body. All of that costs a pretty penny. Which brings me to two final reasons why we continue to worry about ISDS: costs and procedure. These cases are risky and expensive, and it's not clear that every state can bear the risk or cost. In Canada, the claim was for $500 million, Canadian dollars, and Canada laid out $6 million, actually a little bit more, before being reimbursed for 75% of that. Uruguay could never have defended itself or paid a judgment, which would have probably been larger than its GDP. It won because Michael Bloomberg financed its defense. In an HBO expose about the dispute, John Oliver noted that Philip Morris had sent letters to other really poor countries, Togo, the Solomon Islands, and Namibia, threatening, quote, an incalculable amount of international trade litigation if they didn't pull their tobacco packaging legislation. Making it even scarier, the letter said that an Australian High Court judge had already found that plain packaging was an expropriation. Togo, perhaps not realizing that the opinion that had been given was a dissent, not the majority opinion, did indeed reverse its tobacco measures, and several other countries threatened with ISDS challenges have reversed other health-related measures as well. As to procedure, consider the situation in which Australia was originally put. First, Philip Morris brought the domestic case, which Australia won over that one dissent. Then Philip Morris, stymied by the absence of a bid between the United States and Australia, reorganized itself so that it could go after Australia under a bid with Hong Kong. 6 months after that complaint was filed, Australia was brought before the WTO by, of all countries, Ukraine. Ukraine's a pretty poor country. It doesn't have a tobacco industry, and it doesn't have trade with Australia. So you have to wonder what was going on there and whether they were sort of urged to do this by a company whose initials might perhaps be PM. So now the Hong Kong case was later dismissed as an abuse of right. Oh, here's a picture of the Ukrainian minister when John Oliver told her that Ukraine had brought this case. Totally flummoxed. So we have to think maybe Philip Morris was behind that. Now the Hong Kong case was later dismissed as an abuse of right. But think about the original plan. Force Australia to spread its resources thinly, defending itself in 3 different sets of tribunals almost simultaneously. Even a well-resourced country might have trouble doing that. And the prospects of it would surely make it think twice before it regulates IP. Winning a few cases simply won't take the teeth out of the threat of ISDS, and I'll turn it over to Susie to talk about how we think investment obligations should be reconceptualized.
Okay, so as a result of some of the publicity around ISDS, which really extends beyond intellectual property, but particularly the tobacco cases, there have been a number of countries that have really looked to, well, how can we change the situation? And so I'm just going to give you an overview of some of the new agreements, new trade agreements, which include both investment chapters and intellectual property chapters, to see what's happening there. As you can see, we still conclude after looking at some of these that there are many questions left wide open. So let's begin with the Trans-Pacific Partnership that was. This article, before the US withdrew, this is in fact really the equivalent of the article that was in NAFTA that led to the Eli Lilly dispute. So there's quite a lot of detail in here, but the point is that it really touches on intellectual property, but really brings in this idea that it should be in accordance with the TRIPS agreement. So you start to have this, well, maybe there's an investment problem, but if it's in accordance with the TRIPS agreement. So I'm not going to go through some of the detail of that, but simply want to mention, as some of you may know, of course, one of the first acts of the current President of the United States was to take the United States out of the Trans-Pacific Partnership. The other 11 members, for better or for worse, have insisted on continuing with it. And in fact, what they have done in the IP field is strike about 20 clauses from the IP chapter. Time doesn't permit me to go through that. There was a bit of publicity, actually, some of which generated by Professor House over here, about the New Zealand Prime Minister's approach to investment. The new version, now known as the Comprehensive, yet still progressive Trans-Pacific Partnership, which is a clear invitation for countries to, I don't know, rejoin should they wish, or for others to add themselves in the future, is going to have some changes around investment and the ISDS provisions. Until we get the actual text, it's not clear how much that will affect intellectual property. The concern, particularly out of New Zealand, is how it affects the somewhat increasing enthusiasm to invest in the land of New Zealand. Now, that's kind of another topic, which I'm happy to discuss over coffee, but the point here really is, actually, with this change in the text, there's also negotiations in the Pacific known as the Regional Comprehensive Economic Partnership. And with the overlap of many countries between these agreements, actually what's pretty clearly going on is an attempt to make them actually the same. So why do I mention RCEP? Because in fact, RCEP began with this TPP text, and now we have it being changed. So hopefully there is at least some coordination between what our ISDS will mean in the Asia-Pacific region, and there are many nuances to that. So that's one approach. It still really invites cases because it invites ISDS tribunals to consider compliance with other parts of free trade agreements. Now, here's something that's completely different. So this comes out of India's model bilateral investment treaty. And you can see it says the treaty should not apply to the revocation, limitation, or creation of IP rights to the extent that such issuance, revocation, limitation, or creation is consistent with the law of the host state. So whilst many might think, oh, well, that's great, the law of the host state and intellectual property determines this, and indeed it does, it's the opposite extreme of the provision I showed you. In essence, it's really saying we're not engaging with international law. So while some may like this extreme, it's really saying host state law rules here, we're not changing internationally. So the comprehensive agreement between the EU and Canada kind of dives somewhere in the middle. And there's quite a few provisions here, and so I'm just going to highlight a couple of them. But you can see here that the investment chapter actually affirms the parties' rights to regulate to achieve legitimate policy objectives, including such things as public health and cultural diversity. So, you know, those notions, public health and cultural diversity, are of course some of the possible underpinnings of, as we'll hear later, human rights issues, but also have a very close relationship to intellectual property. Okay, so you can regulate for these policy objectives, but this also leaves quite a lot open, and I'll come to that in a minute. If you look at paragraph 2, it tries to address some of these concerns. For greater certainty, the mere fact that a party regulates, including through a modification of its laws, which negatively affects an investment or interferes with an investor's expectations, including its profit expectations, does not amount to a breach of an obligation. So when we first read this, we thought, okay, but then hold on a minute, it also doesn't actually tell you at what point there is a devaluation of the asset. So it still invites litigation about, well, is 80% health warning a devaluation, and so on and so forth. Now, here's another part of CETA. The significance of this particular provision is really how it relates to the previous one. I'm not going to go through the detail, but really summarize for you a point which is this. Well, how much difference do these carefully designed, and please take my word for it, there are carefully designed provisions, and I've given you a couple. There are more in annexes that affect IP and so on. How much difference does it make? And we go through this in detail in the paper, but we conclude that the combination of these provisions actually may not decrease disputes. Instead, future complainants will question whether the relevant regulation actually furthers a legitimate policy objective and whether it does so appropriately. So as Rochelle explained, Lilly in this context left the gate open for future disputes. Significantly, we see in CETA there are no provisions that direct the analysis to external intellectual property norms or give any kind of detailed illustration to explain what an IP expropriation is. And as much as we support the idea of carving out public health and cultural diversity, it's simply likely that these terms are just too broad and arbitrators will kind of make what they consider appropriate on a case-by-case basis. And then this notion of consistency with TRIPS, well, consistency with TRIPS is in the eye of the beholder. That's why many of us specialise it as an area, because it's arguable, right? So at best, CETA and agreements like it ensure that states may prevail more often. That's a possibility, but it does not address the problems that the Philip Morris dispute and the Lilly dispute do, as Rochelle illustrated, in leaving the gate open. So, as I indicated, there's even more, but we'll go through that. So, one approach, of course, is to amend your BITs, amend your trade agreements, and just not give into ISDS. And of course, there are a number of countries that have threatened to withdraw and have withdrawn from this, but not necessarily so much some countries in the ISDS space. What they're trying to do, as they showed, is amend the agreements. But we think you have to do more. For reform to be meaningful, the goal actually must be to reduce the potential for challenges. And one of the ways to do that is to actually ask really if there is jurisdiction, which requires a discussion of when is IP an investment. And we also suggest that there needs to be a more full engagement with, in fact, what IP rights really do. So as Rochelle explained, there is this criteria for patents, and they're kind of flexible. And I'll come back to that sort of flexibility a little bit more. So investment law itself, on which I don't purport to be an expert, and there are many experts, but I've actually read quite a lot of it lately, and it's really clear to me that investment law does not readily accept that something immediately falls within the definition of an investment, whether it's a definition found in a BIT or an FTA, and some of these definitions refer directly to investment, covered investment, asset, and of course the related concept of investor. Many disputes, in fact, particularly at the jurisdictional age, discuss the full characteristics of an investment because, after all, an investor must make an investment, right? Okay, so we see a little bit of that in Philip Morris and almost none or relatively less in the Eli Lilly case. There are a number of ways in which the investment agreement, so the Convention on the Settlement of Investment Disputes, which frames this whole ISDS procedure, or at least a considerable part of it, refers to the notion of international cooperation for economic development, and then there are rules that expand into the idea that an investment must involve the economic materialization of an investment requiring a commitment of resources to the economy of the host state by the claimant, entailing the assumption of risk in expectation of a commercial return. So in the IP space, the crucial question is, when has an IP holder actually done enough in the state to invoke investment protection? Returning to Lilly, it shows the problem. So Lilly did not invent the compounds at issue in Canada. It didn't find the new uses there. It didn't test them there or manufacture them there. Instead, therefore, it had to base its claim on significant investment decisions, as it described them, in relation to the drugs, such as investing in regulatory approvals and marketing. There are many reasons why this is problematic, but particularly given that the patents were the same roughly as the US patents. One was applied for under the Patent Cooperation Treaty. All that's happening in Canada was the registration of a right. So in a prior NAFTA case, the tribunal had actually held that the expense incurred in the pharmaceutical regulatory approval process was not an investment because the company's activities that it undertook as a foreign exporter of goods into the territory of the NAFTA party did not invite investment in the home state. So in our first article that Rochelle referred to, we suggested that the mere registration of an IP right could be analogous to the regulatory thing, and the mere existence of a right without additional investment just isn't an investment. It is, in fact, a functioning of trade comparative advantage, right? You manufacture what you're best at. Some people just get to export. But since all of this, there's also been another dispute, and this dispute is about trademarks again. Now, in this dispute, in brief, the Firestone Company is bringing proceedings against the government of Panama, asserting that it has had a lack of fair and equitable treatment and expropriation of its trademark. The alleged investments are not just the trademark, but also licensing rights derived from the marks. And this is important because, in fact, if there is value in an IP right naked, without other investment, it is the potential to license. So in that case, there's also questions around acquisition of the shares in the company and so on. This tribunal hasn't yet had its final award. The decision that exists is actually an expedited objections decision. The tribunal actually concludes quite directly that the mere registration of a trademark in a country manifestly does not amount to or have the characteristics of an investment in that country. It confers no benefit on the country where the registration takes place, nor does it create any expectation of the profit for the owner of the trademark. So this is your blank IP right without extra in-state investment. In the next paragraph, however, in this expedited decision, the tribunal says the picture is however transformed if the trademark is exploited. And the decision goes on to discuss a little bit what that exploitation is. It does, however, deal with the issue that sales themselves may not be enough, licensing is important, and so on. So, okay, this tribunal agrees there needs to be more in-state investment. We still have questions around what that will be, and it will vary from case to case. Of course, in Philip Morris, as Rochelle mentioned, there was an investment, this is Philip Morris in Uruguay, because the activities of the company in Uruguay weren't just the registering of the trademark, but they were a number of activities that went with it. So they didn't consider this isolated issue that Bridgestone and Firestone did. Now, in the Philip Morris case, there is also, in my view, a significant lack of engagement with the international relations between the parties in terms of intellectual property. There is some, and Rochelle mentioned some of that, and I'm not going to dwell on this point for a long time. I'm going to flag it. Again, Professor House is a bit of a VCLT 31.3c expert, and this is, of course, the rule of treaty interpretation that says you have to look at any relevant rules of international law applicable in relations between the parties. And the Philip Morris Uruguay Tribunal does this. It looks at the rules of international law as they relate to police powers, the notion of public health, and so on. And it's very conversant with 31.3c when it says we don't just have to look at the ICSID convention, we have to look at the context of the bit. And so I'm waiting for the next page that says, and we'll look at the intellectual property relations between the parties, but that last part is missing. So the definition of investment itself. So many agreements, and Rochelle showed some of these at the beginning, but roughly one example is to define the investment to include intangible property that is acquired in the expectation or used for the purpose of economic benefit or other business purposes. That's a good explanation. Sometimes it just says intellectual property, sometimes it lists the type of intellectual property, and so on. So what this means is that the only parties entitled to bring the investment disputes are the holders of intellectual property rights. And because of these investors use ISDS, they are likely to perceive the value in IP, and of course the ISDS itself system is about protecting investment property. So it's very rare for any ISDS challengers to do something which does anything other than challenge a decrease of protection. And so it's for this reason that we say, in fact, the ISDS system has a structural imbalance. A state can raise the level of protection for rights holders without triggering ISDS complaints, but if it tries to safeguard public interests, it can anticipate the possibility of a challenge. Of course, this is actually similar in free trade agreements relating to IP without the ISDS forum, and many people in the room have written about that. But that leads us to suggest that maybe ISDS could in fact be restructured in a way to reduce the systemic bias by recognising that investment also occurs as a result of the absence of IP. For an example, a firm might expend resources inventing around a patented invention in the expectation that the claims in the patent will be interpreted in a particular way. Lily's case, it might have been anticipated that the patents would expire, not necessarily that there would be a new use. And an artist might create, just to swap to copyright, a work in reliance on a copyright exception, such as fair use, or even still, a large internet platform of some kind or another, maybe examples occur to you, might rely on copyright exceptions in order to host much of its content. So If there is in-state investment in these circumstances, there may be an ISDS type of claim. But the international system doesn't quite recognise in the IP space this multifaceted nature of IP. In our view, it makes little sense that investors should not also have reliance interests on the use of the exceptions. Of course, exceptions are not only used by investors, they may be used by individuals, but the same could be said for the rights side of the equation. If the creation of new exceptions to rights, such as broader experimental use in patents, access right and copyrights, can be challenged as expropriation of investment, and those are the kinds of cases that we illustrate in the paper we think can very well happen, then the removal, the expropriation, or unavailability of protection at domestic law, the fair and equitable treatment of those exceptions should actually trigger equivalent rights for those who invest in the exceptions. Significantly, similar approaches can be based in human rights. Daniel Gervais, our host, has actually proposed that ISDS panels consider human rights norms when interpreting the scope and depth of regulatory leeway. We come to human rights later, so I'll be brief on that. So in our view, developing analogous international investment protection for reliance on limitations and flexibilities is actually a way, potentially, to inject balance into the system. Such a system, we suggest, might actually make ISDS arbitrators, who of course aren't really IP-focused very often or trained in IP, more sensitive to what we describe as the public interest side of the IP equation. We do note that broadening the notion like this would actually increase the number of disputes, something that we regret but consider pretty much inevitable at this stage, but it would for some actually be a way to recognise user rights, if we call them that, on the international stage. So, in summary, prior awards provide this roadmap for more cases. New trade agreements, IP chapters, investment chapters only partially address the issue. ISDS actually requires, in our view, an analysis of when IP is an investment in the state, i.e. a naked IP right versus IP plus investment in the state. The Firestone and Panama decision is an example of this in the trademark context, very explicitly stating that the right itself is not on its own an investment. We consider that patents and copyrights as naked rights are also not investments, but they require their own analysis as to what is in-state investment. So in the patent context, that might be building labs, not necessarily building manufacturing facilities, research facilities, employment, and so on. We're not bothered by the idea that some IP rights will not give rise to investment disputes for a number of reasons, but in part we are suggesting that you can't reap your comparative advantage, right? Just export to a country, not invest in it. That is the trade game. You can't reap your benefit of the comparative advantage and also claim an investment. If you make an investment, okay. So investment, we say, should improve its approach with IP by embracing not just the right side of IP, which it can comfortably recognise as property, but actually recognise that investments arise from the absence of IP. There's a lot more, but we'll leave it there. Thank you.